Righty-ho. Okay, so this one is about parking tickets that are handed out to you by traffic wardens. For any other type of parking tickets, which are the camera triggered parking tickets, well, they can be handled in exactly the same way as I detailed in the speeding tickets chat. So the process is the same. You're basically asking them to prove that you are actually there. The camera is what's capturing you there, but that's not a witness, and you know the pictures that it generates aren't really evidence. So yes, this is just for those parking tickets you get from traffic wardens, and it requires a different approach. But before I start, I want to kind of address a little issue. I keep hearing people bashing the idea of free man on the land. You know, I've heard a lot of groups out there saying, yeah, ridiculous free man on the land argument and blah, blah, blah. The term free man on the land has been weaponized in the same way as the word conspiracy theorist. It's there to make people sort of disregard it. Free man on land was a very, very powerful movement in its day, because up until then, nobody was really challenging the system. The system was just oppressing people with no challenge whatsoever. And then the free men came along, and you know, in the heyday of free man on the land, I mean, it was an amazing time. There were giants in that movement, and we were getting a lot done. But there are people now saying that they have got the answer, they've got the special sauce, and all the other approaches don't work. This free man on the land movement type thing, it doesn't work. What they failed to remember is that the bread and butter of our approach to this came out of the free man on the land movement. You know, the notice of conditional acceptance. They call it the 3-letter process to try and you know, make it seem like it's something different, but it is, but just exactly the same as the notice of conditional acceptance. So you know, the people saying that there's one answer to this, there's one approach, is missing you know, what we learned as free men on the land. There is not one answer to this. As soon as we found an approach that essentially stunned a judge and made them want to dismiss the case just to get it out of there, you know, maybe one or two other people tried it and got successes, but then we found that the judges would get together and figure out a new way around it. And you know, then the next person who goes in there, they get beaten down, and that's it. We have to go back to the drawing board, right? There is no one answer, right? One right answer, because you come up with this thing, they find a way around it. Yeah, they're masters at this. They've been doing this for thousands of years. Yeah, the actual players are different, but the playbook is the same. The right answer is that we are being conned, and we have to stand up to it. You know, the actual method doesn't really matter, right? Because, as I say, they will find a way around it. The difficulty for them is that they have to find a way to keep the fraud going and make it look like it's justice. Because essentially they are walking a tightrope. They're walking a tightrope because they know if the mass of people start to realize what's going on, it's all over for them. People lose faith in this justice system, right? Then you know, well, that's where revolutions start and heads start rolling. So they have to, whatever they do, they have to make it look like it is actual justice, and it's not them trying to hide fraud and deceit and keep us all in our places. So this is, you know, I've said this before, those who, you know, who come up and the first thing they say is, does it work? Does the template work? They're missing the point, right? Because again, reiterate what I said last time, it's not about the template, it's about you. It's about you figuring out what's actually going on and how you're going to approach it. If you're confident enough, it's not about the template. Yeah, it's about how you approach it and you know, how you respond. Right? If you've got the knowledge, you'll know what to do, and it will work because you will make it work. But those people who immediately say, "Does it work?" in my opinion, are cowards. Right? They're the type of people who will only fight when the fight's already been won by somebody. In any movement, there's always a vanguard of people, a small number of people who are willing to put themselves at risk and fight, even though they don't know they're going to win. But once the fight's been won, right, that's when all the others come out and say, "Oh, okay, it's safe for me to do so, so maybe I'll come out and fight too." You know, this is the time. You know, if there's any time in history that it's the right time to fight, it's now. Now that, you know, most of the population has succumbed to poisoning. Now that the enemy has actually come out of hiding and their agenda is laid bare, this is the time to fight. Now, I'm going to be doing something about mortgages soon. They're coming after everybody's house, whether you're in a rented place or you've got a mortgage, or even if you haven't got a mortgage and you bought the place outright, still not yours. They're coming after it. Right, so this isn't the time to say, "Well, I'll hide and hopefully they'll pass by me." No, they're not going to pass by you. So you know, this is the time to fight, and it shouldn't matter to you whether, you know, you're going to win or lose, because the battle is beyond that. Okay, so rant over. Right, so going back to the parking tickets handed out by traffic wardens. Now, the problem with this is that, you know, and this is why it's distinct from the camera-generated parking tickets, is that, you know, a living person, you know, even though they're in the a role of a civil enforcement officer or a traffic warden, right, a living man or woman in that role has actually seen you parking in some restricted area and, you know, physically put a ticket on your car. That essentially is a witness against you. Now, it means that they could, if they wanted to, right, call that witness to stand in front and stand up and testify against you. Not that that will ever happen. That won't ever happen, because the whole thing's a fraud anyway. And, but, you know, they wouldn't do that, but it's a possibility. And if you go back to what I said about the, you know, the system fixing any loopholes it discovers, that's still a possible weapon in their armory. So that's how it differs. There's a living witness right there, and that could be used against us. So what we're doing here is, and this goes for everything we do in this game, we use a kind of mental judo. So turning their own strength against them. This also goes back to what I said in the last chat about changing the parameters by which to play the game. So the game is rigged. Obviously, we know that. The game is rigged, and what they do is they set out a path for you to follow to get through this. And that path, you know, inevitably leads to you paying or being punished in some way. The best way to navigate this path is to go off-road because they're not set up for people to deviate from the script. So as I said, the best way to deal with this is to use their own power against them. What they're using against us, we turn around and use against them. So that's why you can't use the same approach as before, because they have that witness. So in the case of parking tickets, there's what's known as an adhesion contract. Now, an adhesion contract is a kind of assumed contract, which is a sort of take it or leave it contract. There's a notice somewhere that says, if you park here, you agree to the following terms and conditions, and here's our fee schedule. It is activated by performance. So as soon as you park there, it's deemed that you've agreed to their conditions, and so you're liable to pay whatever fees. So you'll find, car parks, supermarkets now, even motorway service stations will have notices. I think I saw one in a motorway service station that says if you're here for more than 2 hours or something, we're going to start charging you. But that's their notification of their terms and conditions. Even the council puts up notices. Now, the council are pretending to be a local authority, something above reproach, and you can't really challenge them. But there's this thing called Clearfield Doctrine. Now, Clearfield Doctrine basically says that if a government agency, or even a government or any agency that purports to be anything other than a company, if they start acting like a company, then they lose their right to be anything else. So if they start acting like a for-profit business, then that's what they are. Even when the council puts up their notices and with their terms and conditions, right, you're not dealing with a local authority. You're dealing with a company who's got just as much power over you as Burger King does. Don't be intimidated by the fact that it's the council. So they put their notices up, and that's what traps you. It's your notification of what's going on, and you have to accept their terms and conditions. But here's the thing: you can create your own notices. We're all equal under the law, so you can create your own notices, and and I'll show you in a minute that you can create a notice, put it in the windscreen of your car. That notice has just as much power as the notice that the council put up. One other quick thing I'd like to mention at this point is the Bill of Rights Act 1689. The Bill of Rights Act 1689 is a constitutional statute. One of the things that's in there is that you cannot be fined or suffer any forfeiture before conviction. Now, that's important because in this country, you're considered innocent until proven guilty. Now, that's obviously very powerful. You can't punish an innocent person. If they're presumed innocent, you can't punish them. That's the spirit of this act, that you're innocent until proven guilty. So them imposing fines before you're taken to court and it's proven that you've done something, that's unlawful, illegal, and treasonous. Because if you violate a constitutional statute, then that's treason. But we'll get into that a little later on, and how that affects us when I get into a process that I'm actually in at the moment. So I've there's a group I go to every week.
Shout out to the Sea Haven Massive.
So I go to this group, and what I've been doing is I've been sharing the correspondence from this council every week, because it's quite fun actually. So and I'm going to go through that correspondence with you guys too. So let's go on to looking at this notice. This is the notice that I actually have in my car at the moment. Now I'm actually going to modify it. So once I make the modifications to it, I will put it up in the group. The modification I have in mind is to rebut any presumption of any contract. So I'm going to put something like, I will not be entering into any contracts today. any presumed agreements or contracts you feel you have are withdrawn, and so on, so on. So that's really to combat things like getting some charge for going over a bridge, a dart charge, for instance. That's one that I particularly don't like. But anyway, that's for later. The notice starts with notice, right, in big bold letters, and so that you can't help but notice it, right? So private property, not for hire, exempt for levy outside the jurisdiction of the United Kingdom. This is for when you deregister your car and you start traveling rather than driving. But you don't have to have done that to use this notice. So it goes on. Any persons, including but not limited to, I'll stop there for a second. You might have seen that phrase around in various places, included but not limited to. Well, that comes about because of the word include. Include, in legal terms, if you look it up in Black's Law Dictionary, you won't find a definition. You'll find a line of Latin text. And that Latin is
inclusio unum est exclusio ulterius.
What that means is the inclusion of one is the exclusion of others. It's a very tricky bit of word magic, which means that if you include something, well, whatever it is only refers or applies to what you've included. Anything else is excluded. So if you say, if I said here, including traffic wardens, it means just traffic wardens, right? Which is the opposite of what our minds would naturally assume is the case. So if you use the word including, you might want to make sure that you're not limiting yourself there. So including but not limited to civil enforcement officers, DVLA officers and or their third-party agents, police, community support officers, private revenue officers, traffic wardens who film, photograph or attach anything to this private conveyance, including but not limited to parking notices, PCNs and wheel clamps for the purpose of generating revenue, will thereby be entering into contract with us, therein agreeing to the terms and conditions of said contract, including but not limited to the fee schedule as detailed herein. Number one, you agree to pay £250 for each notice that is attached / issued to this private conveyance. So if they stick something on your car, or if they issue something in the name of that car, then this fee applies. You agree to pay £125 for each image / photograph you take of this private conveyance. If you clamp this private conveyance, you thereby agree to pay £500 per hour or portion thereof until the clamp is removed. If you move, relocate or tow this private conveyance, you thereby agree to pay £750 per hour or portion thereof until the private conveyance is returned to me, its lawful owner. An asterisk applies to the clamp. We reserve the right to remove the clamp at any time for a removal fee of £800 sterling. You may apply the cost of any damage to the clamp, which may be deducted from the removal fee upon receipt of valid proof of purchase. So I just added that one in at the end because they like to cry criminal damage if you damage their clamp. You can get around that basically by saying, well, yeah, I'm removing it because it's on my property, but if it's damaged, then I'll happily repay you, and I'll give them my conditions for repayment there. And just as they expect us to have all the receipts for things, if for proof of purchase, I don't think they've got receipts for their clamp either. So that was the actual notice that was on my car. And recently, when I went to Canterbury, hello Nikki. When I went to Canterbury, I parked in it turns out a residents only spot. So yeah, I parked in a residents only spot, and when I got back, there was a parking ticket waiting for me. So what I did was, yeah, I got the parking ticket, and yeah, this was a notice of conditional acceptance I sent out. So, dear Sir Madden, I am the authorised representative for Mr. David Murphy, and I'd like to thank you for your unsigned offer of a penalty charge dated blah, 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 which was eventually removed by the windscreen wiper. I put that on there because it said to be removed only by the driver or something like that. So just by picking it up, you're contracting with it. So I just thought I'd put a little thing in there. I've noted the content of your notice and I return it to you. Again, standard practice for anything you get, make a copy of it and return the original to them. Now, somebody actually apparently got confused and thought I meant fill it in and return it to them. No, you just send their paperwork back to them, because by holding on to it, you're accepting it, right? If you're not going to accept something, send it back to them, okay? So your employee, Civil Enforcement Officer 77, would have noticed the notice prominently displayed in the windscreen of the private conveyance, a copy of which is enclosed, and decided to accept the terms and conditions therein and contract with me on your behalf. So I put a picture of the car with a ticket in the window and my notice displayed there. I would like to draw your attention to item number 1 of the aforementioned notice, where it states, you agree to pay £250 for each notice that is attached or issued to this private conveyance. I've also enclosed an invoice for £250 with regard to the above fee, payable upon receipt. Please pass this to your financial department forthwith. With regard to your penalty charge, I'm more than happy to accept it on condition that either the penalty charge is deducted from my fee and you send a cheque or money order made out to Mr. David Murphy in the amount of £215, or you send a cheque or money order made out to Mr. David Murphy in the amount of £250, and I will send a cheque or money order in the amount of £35 upon receipt. Thank you for your custom. I hope we can do business again in the future. So, again, have a little bit of fun with this, and you know, not only because yeah, it's a bit of a laugh, but it will dispel any fear that you have of this process, because they're actually having a laugh with you doing this. So this was the response from Canterbury. Thank you for your letter received, blah, blah, blah. To confirm, the notice in your car does not form a contract with the council and does not exempt a vehicle from parking restrictions at any time. No payment will be made to you as you request. The penalty charge with notice was correctly issued under the Traffic Management Act 2004 and all these bloody so-called bits of legislation. I have to advise you that grounds for representation against the penalty charge have not been established, and you have given no mitigating circumstances to warrant using our discretion on cancelling the penalty. You may either pay a reduced amount within 14 days, beginning with the date of this letter, blah, 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 blah. So I don't know if you noticed anything there. The first claim they made, the notice in the car does not form a contract with the council. So they're trying to say that an adhesion contract, exactly the same as the one that they're using to impose this parking restriction, right, does not form a contract. Okay. And it doesn't exempt the vehicle from parking restrictions. That's not something I'm claiming. I'm not claiming that the notice exempts a vehicle. It doesn't. It doesn't exempt anything. It's saying that I'm charging you for putting a notice on my car. Got nothing to do with that. And they're saying, well, no payment will be made as you request. Nice. That's good. The penalty charge notice was correctly issued under all this legislation. Well, I never asked if it was issued correctly. I never challenged that. again, what they're doing is trying to steer the conversation into a different direction. Because again, like I said last time, it's about shoehorning you back into their process. Right now, I've strayed off road. Yeah, there's the path they've laid out for me. I've strayed off road. Right, so now they're trying to say that I'm not exempt. Right, there is no contract, because they're not used to people saying this, and now they're trying to say that I made some kind of representation, which is something they can handle, but I didn't make a representation. Right, so that's basically what they're trying to do. They're trying to shoehorn me back into their process, and if I don't really rebut any of these claims that they're making, then then these claims stand. Right, so then I have made a representation, and I have been trying to challenge the issuance of the penalty charge notice. Again, no, not doing that. So let's go for the next one. Right, this one. Okay. So the notice of default and opportunity to cure. Right. So again, if you've done the so-called three-letter process, this is the next one. And again, if for people who come back to me and say, well, okay, I haven't got a notice of default and opportunity to cure, what do I put in it? I mean, it's a standard format. You don't really need to have a sample. What you're doing, and this goes back to understanding what you're doing with the notice of default and opportunity to cure is reiterating what you've asked for before, and then giving them a further opportunity to answer your questions because they failed to do so. That's it. Right? You don't need a template for that. Right? It's literally just a continuation of the process. Right? In this case, not only are you going to give them the opportunity to cure, you're going to rebut the claims that they made. Right. So, dear Mr. Business Support. Well, that was what was on their letter. It was business support, wasn't signed. Thank you for your unsigned letter dated blah blah blah. We have noted its content and returned it to you. Please take note that we did not dispute any of your claims, nor did we make an appeal or a representation. However, it appears that you have misconstrued or misunderstood the purpose of the notice of conditional acceptance dated blah blah blah. That was served upon you via first-class mail or first-class signed form mail, and put the delivery and tracking number and everything. The aforementioned notice advised you that your employee, Civil Enforcement Officer 77, noticed the notice that was prominently displayed in the windscreen of the private conveyance, highlighted on the photographs that you so kindly provided, and therefore decided to accept the terms and conditions therein, thus contracting with me on your behalf. Once again, there is no dispute, no representation, and no appeal. Item number 1 of the contract that Civil Enforcement Officer 77 entered into on your behalf states you agree to pay £250 for each notice that is issued attached to this private conveyance. We conditionally accepted your parking charge on the condition that you pay the above fee. An invoice for £250 was issued to you, and you were provided with 2 options for payment upon receipt, whereupon we would issue payment in accordance with your charges. That is, if you opted not to deduct it from our fees. We note that no cheque or money order was made out to Mr. David Murphy in the amount of £250 or £215 was found enclosed with your letter. Yet you continue to demand payment, so you are now in default of our notice. We are, however, reasonable, and we understand that your failure to respond may have been an oversight, mistake, or otherwise unintentional. We therefore grant you 7 days from receipt of this notice to remedy this fault in good faith and make payment upon the invoice that you accepted, because they didn't send that invoice back. So the rules that they try and apply to us, we can apply to them. They've accepted the invoice. Anyway, rules that the invoice that you accepted on that date, failure to respond in good faith according to the above criterion will be deemed to mean that you've dishonoured our contract and will incur an additional £100 penalty. and shall result in recovery action being taken against you. So again, just as they sweeten their deal by saying if you pay now, it's only £35, but if you leave it till later, it's going to go up to 70 quid. Yeah, so I've given them the same option. Right, so let's move on. In response to your letter received on blah blah, you have not offered any relevant grounds of representation. So you can see there, they're still trying to say that you made this representation. I didn't make a representation. I just informed them of the terms and conditions of the notice they entered into. The question of contract law simply does not arise. Looking at the contemporaneous evidence and the terms of the traffic order, regulation order that governs parking in this bay, the council is satisfied that the contravention occurred. I didn't say the contravention didn't occur. And that none of the statutory defences apply. I'm not making a statutory defence. Consent is not required. Oh, consent is not required. That sounds like slavery to me. If somebody can do something against you without your consent, that's pretty much slavery. Yeah. There is no contract signed or accepted by the council that owes you money. Ooh, that's nice. Actually, we can use that. The penalty charge notice does not represent a contract. Well, nobody says it represents a contract. It is a notice issued in accordance to these terms. Again, they go through a whole load of legislation just to make it seem like it's there's something real there. Blah, 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 indicating that a penalty has occurred and is payable for contravening a parking restriction. The quoted Bill of Rights / Magna Carta. Hang on a second. Who mentioned Magna Carta? Well, I didn't. Not only does that tell me that lots and lots of other people are challenging these things, and using the Magna Carta, well, the Bill of Rights and the Magna Carta together, because the Magna Carta, I think it's Article 39, also says that you can't be fined or suffer forfeiture without conviction. So other people are doing this, but I didn't. So again, this is them with a kind of standard form letter. So Magna Carta has no bearing on the issue of a penalty charge notice, and there is no contract with the council. Therefore, the notice in your vehicle does not exempt a vehicle from parking restrictions. It's quite right. My notice doesn't exempt my car. It just puts an onus on them as well. So in 2006, a senior High Court judge, Mr. Justice Collins, interesting, they called him Mr. Justice Collins, demolished the belief that the 1689 Bill of Rights outlaws parking charges because they have not been imposed by a court of law. The parking charge notice was issued as the vehicle was parked in a residence or shared use parking zone without a permit. There is clear signage to identify this restriction. All right, yeah, we remain satisfied, and them sitting there satisfied again, that it was correctly issued. Nobody said it wasn't correctly issued. Your grounds for a representation. Nobody's making a representation against the penalty charge has not been established. They're saying it again. You may now either pay the reduced amount within 7 days, blah, 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 all this stuff. Same thing. You should be aware that if you appeal to an adjudicator, the reduced payment of £35 will no longer be applicable. Yes, they want you to go to an adjudicator because apparently, now I've got to sort of check up on this. Apparently, the adjudicator is or the adjudication service is paid a certain amount of the PCN. So they're not really a fair adjudicator. They've got a conflict of interest. They get paid from fining you. So so that's it for that notice. So let's go to my response to it. So my response is a little bit of a departure from the four letter or 3 letter process. I I decided to give them a notice of default and further opportunity to cure. So, dear Mr. Business Support, thank you for your unsigned letter dated blah, blah, blah. And just to step back a second, an unsigned letter has no legal effect whatsoever, right? Because nobody is taking responsibility for it. They don't sign it. A living man isn't signing it. That means nobody, there's nobody to come back to. It just makes it worthless. So on the 10th of October, blah, blah, a notice of default and opportunity to cure was served upon you. The aforementioned notice was not an attempt to appeal. Rather, it reiterated our agreement to accept your penalty charge on condition that you pay our charges arising from the contract entered into by Civil Enforcement 77 on your behalf. You are granted a further 7 days within which to pay. However, by this date, nothing had been received from yourselves and no check or money order was made out to Mr. David Murphy in the amount of £250 or £215 was found enclosed with your letter. Moreover, you have refused to pay and make the claim that our notice does not form the basis of a contract, and as such, nonetheless, you are in default. Before we consider action against yourselves, we'll grant you a period of 7 days to prove your claims in accordance with the following maxim: semper necessitas probandi incumbit qui agit. The claimant is always bound to prove. The burden of proof lies on him. Right. So this is a legal maxim that, is apparently self-evident in law and can't be challenged. So whoever makes a claim, got to prove it. So number one, please provide material evidence, not opinion or hearsay, that proves beyond the reasonable doubt. Now, if you're going to write a notice and you're asking for proof, always write it like that, right? Because it doesn't give them any wiggle room whatsoever. Yeah. Proves beyond a reasonable doubt that Civil Enforcement Officer 77's act of agreeing to the terms and conditions of our notice by performance does not form a contract. Well, it does, and that's the same kind of a process that they're actually relying on to pursue this claim. Number two, if you're asserting that your claim is supported by legislation, then please provide material evidence, not opinion or hearsay, that proves beyond a reasonable doubt that said legislation has repealed the Bill of Rights Act 1689, which prohibits fines and forfeitures before conviction in a court of law, and was upheld in the case of Thoburn versus Sunderland City 2003. Please note, if you manage to provide such evidence, then we will immediately cancel the invoice issued to yourselves on this date, and you may disregard the enclosed invoice. However, we will also apply this evidence to your notice and disregard it without dishonor. So more legal maxims: quod ad jus natural itinet omnes you get it. All are equal before the law. Right? So sauce for the goose is sauce for the gander. Yeah. As per our notice of default and opportunity to cure, dated blah blah blah, we enclose an invoice for £100 as a late payment penalty detailed therein. Please pass this to your finance department forthwith. Failure to respond in good faith and according to the above criterion will be deemed to mean that you've agreed that you owe us £350 and that we owe yourselves £35, and which we shall forward to you upon receipt of payment upon our charges. So again, their responses are designed to make the muggles get scared and think, oh, the template didn't work. Yeah, because their response sounds very official, sounds like they've got the law on their side. But here's the thing: you've got to stick to your guns, right? Because at the end of the day, and with all of these things, you are in the right, they are in the wrong, and they're playing this game of word magic to try and make you believe that they're right. Yeah, it's just word magic. Right, so let's go to. So again, I didn't really even have to show this because you know it's the same sort of thing over again. They've got nothing new. They're just, all they can do is just keep trying to parrot the same thing. In response to your letter, you have not offered any relevant grounds for representation. Again, I did not make a representation. So they're arguing apples and oranges here. Yeah, the question of contract law simply does not arise. Looking at the contemporaneous evidence and the terms of the blah blah blah, the council is satisfied a contravention occurred. Again, not saying it didn't occur. Right? Did I read this already? I think it sounds like I might have got this wrong, but anyway, it doesn't matter. It's the same stuff. This is all they can do. All they can do, right, is repeat and repeat. So let's have a look at my final response. So this is the state of play, and so far I actually received the last one while I was away. Somebody opened the letter for me and read it to me, and I drafted this back to them. So, dear Mr. Business Support Parking Appeals, thank you for your unsigned letter dated 8th of November. We've noted the content with dismay and return it to you enclosed. On the 25th of September, a notice of conditional acceptance was served upon you, said notice accepted your kind offer of a penalty charge on the condition you accepted the charges incurred when your employee, Civil Enforcement Officer 77, decided to accept the terms and conditions of the notice prominently displayed in the windscreen of the private conveyance in question, and thus contracted with us on your behalf. However, on October 5th, a letter was received from yourselves which apparently misconstrued or misunderstood the purpose of the notice, wrongfully assumed that it was disputing your claims and was some sort of appeal or representation. This appears to be a recurring theme. So for the avoidance of doubt, assumption and presumption, we will restate in large bold letters in case you are visually impaired. We did not dispute your claims, nor did we make an appeal or representation. We accepted your penalty charge on the condition you accepted the charges incurred by your agent, Civil Enforcement 77. In a lawful attempt to settle the matter, a notice of default and opportunity to cure was served upon you. This notice granted you 7 days to make payment upon the invoice that you accepted, whereupon we would reciprocate with a payment upon your penalty charge. A letter dated 18th of October was received but contained no payment. It did, however, make the claim that the notice displayed in the private conveyance did not form a contract with Canterbury City Council and did not constitute an exemption. Once again, made the assumption that we had made a representation against the penalty charge, despite clearly indicating that we had conditionally accepted the penalty charge. Once again, we shall make our position clear for the hard of thinking employed at Canterbury City Council. We did not dispute your claims, nor did we make an appeal or a representation, nor do we claim that our notice provided an exemption. We accepted your penalty charge on the condition you accepted the charge incurred by your agent, Civil Enforcement Officer 77. Since your appeal regarding, so I turned that against them, so they made an appeal to me. Since your appeal regarding contracts was an interesting one, we decided to serve a notice of default and further opportunity to cure, dated blah, blah, blah. In this notice, you were invited to substantiate your claim with evidence according to the legal maxim the claimant is always bound to prove. The burden of proof lies on him. You were requested to provide the following evidence. Number 1. Please provide material evidence, not opinion or hearsay, that proves beyond a reasonable doubt that Civil Enforcement Officer 77's act of agreeing to the terms and conditions of our notice by performance did not form a contract. So it's the same two questions I basically, or points that I sort of iterated in the first notice. So I'm not going to read them again. A letter dated 8th of November received by you, which made further puzzling and rather amusing claims, but did not provide any of the requested evidence. Your claim that our liability to pay your parking charge does not arise from a contract is baffling, because in Parking Eye Limited versus Beavis 2015, the case centred on the law relating to penalty clauses in contracts, in particular adhesion contracts formed by the placement of notices in parking areas. So you might want to look up this particular case, because it's it literally says that a contract was formed by notices placed around a supermarket car park. Go back to letter. We also looked up civil penalties and found the following definition. Penalties in English law are contractual terms which are not enforceable in courts because of their penal character. That's from a book, Chitty on Contracts, Volume 1, blah, blah, blah. So a penalty charge arises from a contract, and we note that they are not enforceable in the courts. You are quite correct that a penalty charge notice does not represent a contract. However, the grounds for issuing it are based on a breach of an adhesion contract offered by a notice placed somewhere on Roper Road, Canterbury, and implicitly accepted by performance. Once again, we did not dispute your offer to contract and our acceptance of it by performance. We accepted the penalty charge notice on the condition that you accepted the charges specified within the adhesion contract placed in the windscreen of the private conveyance, the terms of which were accepted on your behalf by your agent, Civil Enforcement 77, by performance. Or if, as you say, there is no contract signed or accepted by the council by which the council owes us money, then there is no contract signed or accepted by us by which we owe the council money. And there's the legal maxim, all are equal before the law. It is also noticed that you brought up the supposed ruling by Mr. Justice Collins, though it cannot be considered case law because case law are made by decisions of juries. Judges merely comment upon the ruling arrived at by the jury. So while Mr. Justice Collins's opinion in this matter is interesting, it is equally irrelevant. Mr. Justice Collins stated, "This is not a fine or a forfeiture within the meaning of the Bill of Rights. The suggestion that the bill applies is a nonsense. It does not. Parking charges are not fines." Of course they're fines. Are not fines for criminal offences. It was implicit in the 1991 Road Traffic Act that they are civil penalties. Now, I've already explained what civil penalties are earlier on. Anyway, the Bill of Rights Act makes no distinction between fines for criminal offences and fines for civil violations. It relates to any fine or forfeiture before conviction. In this country, one is presumed innocent until proven guilty. The punishment of the innocent before conviction is precisely what the Bill of Rights Act 1689 was instituted to prevent, and the general ignorance of this statute invites unscrupulous agencies such as Canterbury City Council to circumvent the people's right to due process of law. The Bill of Rights Act is a constitutional statute, and its status as such was upheld in the case of Thoburn versus Sunderland City 2003, which means that if Mr. Justice Collins's words were even impliedly repealed it, then he committed an act of treason, and any ruling is rendered null and void. You also rather amusingly state that the penalty charge notice was issued to a vehicle. How exactly do you expect a vehicle to respond? We asked our private conveyance if it cared to write back to you, but after a rather entertaining few minutes, it showed no sign that it would put pen to paper, nor did it produce a credit card or any other valid form of payment with which to settle the penalty charge. It is an inanimate object. It can neither read your notice nor respond to your offer of a penalty charge. However, the private conveyance did have a notice in the windscreen that set out a fee for anything attached or issued to it, like the penalty charge notice that you now admit was issued to it. You've served nothing upon us which can be considered a good faith and diligent attempt by you to rebut the validity of our notice, and the contract formed by Civil Enforcement Officer 77's Act of Agreement to the terms and conditions therein on your behalf. You are in dishonour, and we must advise you that a default judgment is now in place, establishing permanent and irrevocable estoppel by acquiescence, that either we are liable to pay the fee attached to the penalty charge notice, and Canterbury City are liable to pay the fees which are stipulated in our respective contracts, or B, neither contract is valid and there is no liability for either party to pay. If we receive any further correspondence from Canterbury City Council on this matter, it would be deemed to mean that you've chosen option A, and we'll expect payment upon the previously submitted invoices for £350 in total within 30 days. And we shall forward £35 to you upon receipt of payment. Failure to pay may result in recovery action against you. So that's essentially my my attempt at judo. And literally what you're seeing there is that they cannot get around it. Yeah, they're doing their best to get around it, but they can't do it. So that is the kind of mental judo that you use against them, right? It does mean that you have to do some preparation yourself. You have to have a notice in your car. It's good practice to have that notice anyway. Right? There's no reason why you shouldn't have that notice in your car, as a matter of course, because it's providing you with a level of protection. Right? I've had a case where that notice sitting in the windscreen. I once parked in a residence parking area when I was there for a party, and a whole load of people also parked there. In the morning, there was notices, there was parking tickets on all the cars except mine, and I can only attribute that to the notice in my window. So it's a good idea to have it there, and because it was there when Canterbury has come after me, that was the result. Yes, it took a back and forth of 7 letters, because obviously they used to be able to intimidate muggles, but if you know what's going on, you don't have to be intimidated. And I actually laughed myself silly when I just thought of adding the thing about the car not responding to them. Yeah, I sat, and the idea that I stood there asking the car if it wanted to reply to Canterbury. Yeah. Anyway, but as I said, if you can have a laugh about it, yeah, if you can put some of your humor into this process, right, the fear of all this will be dispelled, right? So that's pretty much it. It's not about the template, right? It's not even about the process. It's about you, right? It's you standing up to this, realizing that you've been conned and you're not going to stand for it anymore. Believe me, once you've done this for yourself, once you've gone through this process and had this back and forth between the council, and realizing that the council or whoever it is has nowhere to go, they've got no argument against it apart from essentially lying, or not lying, misleading you, because they won't lie to you, but they'll use word magic to make you believe something that's not true. Okay, but if you've got the truth behind you, you can see through the word magic, and also see through the way they keep trying to shoehorn you back into their process by saying, well, you made a representation, or you appealed, or you're challenging the validity of us issuing a PCN. No, all right, you stick to your guns, that you are accepting their process, accepting their PCN, but by the same token, they've got to accept yours. Right, so that's pretty much all I have. If anyone's got any questions, I shall shut up and wait for the questions.
Hi, Dave. It's
Hiya.
Barney.
Hi there.
You're right.
Yeah.
I wanted to ask. Thanks for the talk. It's been great, and I've learned a lot. I see where I went wrong with the last parking ticket now, but I received another parking ticket yesterday, and I'm dying to get my teeth into fighting them, playing them at their own game. So, but how? Obviously I didn't have the notice in my window. How would you begin? For approaching them when you don't have the notice in your window?
I wouldn't. I don't know, to be honest. This is why I came up. This is why I came up with this way, because their process is fairly streamlined. Well, no, okay. Let me step back. When I say I don't know, I guess I would go with Bill of Rights, 1689, because they can't, impose a fine upon somebody who's innocent. So look up the Bill of Rights. Right. Also look up the case law that I mentioned, which is Thoburn versus London City, 2003, because they laid out in that case, and I might post something about that case in the group. But they laid out in that case that that we do indeed have a constitution, right, which is spread out over multiple documents, including the Bill of Rights Act 1689, and it does stand, and that's been confirmed by MPs and the Speaker of the House. I think it was in 1993, who said that we expect the courts to abide by this constitutional statute. So yes, I'd use that. And again, stick to your guns.
Yeah, that's where I went wrong with the last ticket. I did go down the Bill of Rights route, but then they completely engulfed me, and I didn't know how to deal with the next part. But at least I've seen where I've gone wrong.
Right. So yeah, you can take from this notice, which I actually posted the audio version of the last letter on the group. So it says Canterbury something. It's one of the audio files. But yes, you can take what I've spoken about on about the Bill of Rights 1689 and use that in your next approach there. But get a notice for your car.
Yeah, I'm gonna do it straight away. Brilliant, thanks.
You're welcome.
Dave, I have
anybody else?
You.
Hello.
Hello. Just the question I have is, you use the term private car. Do we need to do something with the DVLA? I've seen loads of information flying around in other groups about how we don't actually own the vehicle, and that's worrying me a bit. With their ability to get our information first of all, and then secondly, being able to claim the car is ours fully when it's fully paid for.
Right. Well, here's the thing. When you registered the car, the word register means handing over title ownership of what you're registering with whoever you're registering it with. Okay. So, by filling in that form and registering, your name to that car or registering that car, you've actually given it to the DVLA. Now, people have actually used that against, the DVLA. So when they get the notice to owner, well, they forward that onto the DVLA. So that's another example of this idea of mental judo. Yeah. But yes, you are right. That's the claim they have on your private car, that you've now, by registering it, turned it into a public motor vehicle, right? Which is on the road for commerce. So yeah, the next stage really, if is to deregister that car and try and use it to travel in private. Now, one of the things I want to do when I get back to the UK is, well, I put a call out for anyone who had an old car that, you know, as long as it worked, I would turn into a right to travel demonstrator. And the idea is to, I wouldn't be hiding. I would, you know, write all over the car, like private property, driverless car, and things like that, you know, all over the car. So I'm not hiding. I'm showing that I'm traveling in my own private capacity. I'll deregister it. I'll put cameras around it, and I will film its adventures, and just to explicitly assert our right to travel. So that's one of my next projects.
Sounds like fun. Okay, thank you.
I don't know if that helped.
It does help. I have seen ways in which to deregister the car, but just didn't know what other challenges that would then bring up. So, but yes, thank you for that. Yeah,
the big challenge it brings up is that you know, the police don't have any idea. They're used to muggles out there who believe that you know, that they're driving, and they're not used to people who know the truth. So they will, you know, they see anything odd about your car, they're going to stop you. So what I was planning to do was, with this right to travel demonstrator, is just travel locally, so that I'll only get pulled up by local police, and keep doing it until they start to learn that, you know what, let's not mess with this guy. And then once I get to that stage, then move further afield. That's the plan anyway, and whether that works or not, another matter.
Hey Dave, can you hear me?
Yes, I can.
If I get my car back
Hello.
That was stolen, you have a car. If I get my car back from the council, you have a car. You've got a little smart car. I've got a smart car the council took. You can have it. You can do what you like with it.
Oh wow! Okay,
it's there.
All right. Well,
so I'm using it as a test after they stole it. Yeah, let's see if we can get it back for the council. Yeah, they stole it. You know, what was it? 10 days ago. Let's see if I can get it back. If I do, you can have it.
You're on. If you're on. If it comes off, then please do.
Yeah. I'll keep you in touch.
All right. Thanks a lot, Katie. Anything else?
Hi, Dave. Can you hear me?
Yes.
Yeah, I put a message in the group. I'm the guy that sent the ticket back within 72 hours, and
okay.
And then I started getting the notices, and I just ignored them, and then eventually I got a hand-posted bailiff note put through the door. Then I rang the guy, had a chat with him, explained I wasn't accepting liability, and there's no sign. The court order won't have a signature on it. Blah blah blah. And then he suggested I go back to the court and do a T7, T9. So I did that. Then they sided with the council and said no. They've sent all the notices and everything. The council did a statement of truth saying we've sent a notice this date, that date, and it still stands. So then I emailed the council saying, well, you weren't truthful in your statement of truth because you didn't mention that I sent you your invitation to contract back. So they acknowledged that with a letter saying they put it in the notes. But it wasn't in the statement of truth. And now I've got the bailiff back on me again, and they're threatening to come round within days. So what do I do? Well,
that's an example of you going through their process. Yeah. Right. Even though you returned their paperwork, right? Okay. There's a whole group of people who say that the best way to deal with things is to ignore it, send it back and just ignore it and hope it goes away. And sometimes it does actually work. Sometimes people have got results by totally ignoring it. But when you ignore these things, right, they can deem it that you've agreed to it because of your silence, okay? And then they can start the process. So that's an example of that actually happening. And whenever they tell you, right, you have to do something, you have to appeal using this form, and you're again entering into their you know, their field of battle, right? They've given you something they know is going to fail. If you start giving your power away to them,
we can't hear you, Dave. We can't hear you.
Why can't you hear me?
I can hear you.
Yeah.
I can hear you.
Okay. All right. Well, okay. Everyone else can hear me. It must be your end. Sorry. Yeah. So as soon as you start contracting with them by using their process, well, then you put yourself in their hands, and almost inevitably they're going to say, no, we're going to deny your appeal. Because it's all about money. It's all about trying to get that money from you. Okay, so don't go through their appeal. Don't go through their process. Do your own process. Okay, and again, it's I can't really help you on this one, apart from, as I said to Franny a few minutes ago, I would go down the 1689 route. It might be a bit too late for that, because you've gone really far into their process now. But that's that I think is the only recourse you have in that situation. But
well,
hopefully,
one more thing, Dave. One more thing, then. If maybe I am doomed and I'm cornered, then I can obviously opt for a payment plan, but then I have to sign something. Then would you put VC after the signatures to show that I was coerced and threatened into it?
Well, you could do, but what will happen is they'll say, "Well, you haven't paid. Where's the payment?" So it won't stop. It won't stop, right? Because their goal is to get the money out of you. That's it.
Can I offer them £5 a month and say they have to take it?
Yeah, you can try that. You can try that. Say, I offer you £1 a month, whatever. Yeah.
Yeah.
There's a possibility you could try a promissory note.
Yeah.
Write them a promissory note. Then you get into this issue with is it a valid specie of money, which it is according to case law.
Yeah.
So yeah, you can keep the game going that way.
Yeah. Okay, I'll try that. Thank you.
But hopefully you've seen from this this chat that there is another way of avoiding this, getting into that situation by changing the parameters by which you play the game.
Yeah, thank you.
Good.
Oh, yeah.
Anything else? Okay then. Right. So again, I'll probably turn this into a video and try and get it out in the next week or so. All right. So thanks everybody.
Thank you.
Thank you, Dave. Much appreciated.
Take care, everyone.
Thank you.
All right. Bye-bye.
Thank you, Dave.
Cheers.
Thank you.
Bye.
Bye. Bye, everyone.